Okay, so start recording and we start our presentation. So, last presentation for this section, and it is free speech and human rights in the cyberspace. And this is gonna have two parts. The first one is related to data protection, while the second is related to the freedom of speech in relation with the balance between tech platforms, final users, and authorities to regulate them. So let's see the data protection, and we start from the US perspective. So the first time we heard about a right to privacy came from an influential law review article that was written by Samuel D. Warren and Louis Brandeis, in which they call for a legal right to privacy based on the principle of inviolate personality. They think that the law should protect individuals from invasions of privacy by the press and others modern technology capable of recording or reproducing personal information and sounds. This was very influential even because it links immediately rights to privacy to technology, basically, for what it was possible, of course, at the time. The same person that we have Brandeis, we see it here on the bottom right, was present then during the Olmsted case in 1928, which involved Roy Olmsted, who was involved in importing and selling alcohol, violating the National Prohibition Act. Without a search warrant, agents wiretapped Olmsted's telephone, and the Supreme Court decided that the Fourth Amendment wasn't violated as there was no physical search or seizure. The evidence was obtained through hearing without entering the defendant's premises. This was based on the physical trespass doctrine, right? So Judge Brandeis, that we see before, was influential in its article and in claiming about the right to privacy, had a dissenting opinion in which emphasized instead the right to privacy, stating the right to be alone, and that as a fundamental right, and any government intrusion into privacy without justification was considered by him as a violation of the Fourth Amendment. The Ostem interpretation was pivotal for what later was the Katz case, in which instead the FBI bugged the outside of a telephone booth used by Katz, despite not physically intruding into Katz's space. Katz argued that the phone booth was a constitutional protected area. This case challenged the existing understanding of the Fourth Amendment as it related to the physical trespass doctrine and led to the revaluation of privacy rights in the context of modern surveillance methods. The 1977 then Katz decision established the reasonable expectation of privacy test, asserting that Katz had a reasonable expectation of privacy in the phone booth, and thus the warrantless wiretapping violated his Fourth Amendment rights, establishing that the Fourth Amendment protects people and their privacy rather than just physical spaces. So we have first, with the Katz decision for the first time, the transcending of the normal interpretation of the Fourth Amendment as linked to the physical space, and it comes, of course, related to technology. Now, the latest case that we have that was pretty important in this area was the 2018 Carpenter versus US case, in which the Supreme Court ruled that the government's acquisition of Timothy Carpenter's cell site location information, so as CSLI, from his wireless CSLI, and the expectation of privacy in digital, and hence he remarked and evolved the expectation of privacy much more into the digital age. The court reasoned that allowing government to assess the historical CSLI without a warrant goes against the Fourth Amendment guarantee against what are considered unreasonable search. So we see there was a line from Olmsted in which it was denied, and the dissenting opinion of Brandeis that then evolved into the 97 Katz case, in which for the first time the Fourth Amendment was evolved beyond the trespass doctrine and beyond physical spaces, and then until now, until recently in Carpenter versus US, in which it entered into the digital spaces. Now instead, let's see the more nuanced and complicated interpretation that happens in the EU. And this one is way more longer, because in the EU the context of the right to privacy was enshrined and is enshrined in Article 8 of the European Convention on Human Rights, ECHR, and such article guarantees everyone the right to respect for their private and family life, and it does not, however, address data protection, but focuses on the broader concept of privacy. So you have this concept of privacy that is not well defined into the EU Convention on Human Rights, EU Convention of Human Rights, and then here is where the court interpretation enters into the game, basically. The article allows for interference by a public authority with this right only if it is in accordance with the law and is necessary in a democratic society for various reasons such as national security, public safety, economic well-being, prevention of disorder or crime, protection of health and morals, or protection of the rights and freedom of others. So basically you have this equilibrium between the breach of privacy, and on the other side the necessity that this need to be done, especially in the democratic context, right? A second legal test then is Convention 108, which sets a standards for data protection, including the quality of data, security measure, and cross-border data flows. It requires parties to take appropriate security measures and cross-border data flows. It requires them to take appropriate security measures for the protection of personal data against accidental or unauthorized destruction, accidental loss, as well as unauthorized access, alteration, or dissemination. The EU had seen a significant change and went from a privacy regulation that is related to the business and then to the free market, free movement of goods, of people, and so on, to something way more constitutional, so to becoming one of the pillars of the constitutionalism inside the EU interpretation. And so we actually have seen the history that goes from the Data Protection Directive in 95/46 SC, the e-Privacy Directive 2022/58 SC, Data Retention Directive 2006/24 SC, and then finally the current one, that is the GDPR 679/2016. The constitutional shift in the EU reflects the evolution of data protection and privacy rights. The Treaty on the Functioning of the EU in Article 16 and the Charter of Fundamental Rights of the EU emphasize the right to personal data protection and the respect for private and family life, and involved principles such as the three-step test, Article 52, and addressing the abuses of rights, and Article 54. Now let's see some important cases that had led to the evolution of the data privacy towards a constitutional shift. So we have Peici versus UK. In 2003, the European Court of Human Rights examined the issue of privacy in relation to the public disclosure of closed PEC versus UK. Disclosure of closed circuit television CCTV footage. The applicant, Mr. Peck, complained about the release and media publication of CCTV footage that showed him in a distressed state on a public street. This disclosure led to widespread broadcasting and publication of his image. The court ruled that the release and broadcasting of footage without Mr. Peck's consent constituted a violation of his right to respect for private and family life under Article 8 ECHR. Second case is SM Marper versus UK, so 2002-2003 from 2008. In the case, the ECHR addressed the issue of the UK retaining DNA samples and fingerprints of individuals who were arrested but subsequently acquitted or had the charge against them dropped The court found that this practice of retention constitute a violation of the individual right to privacy, specifically the right to respect for private and family life as protected in the Article 8 of the EHRC. Always in 2008, Ku versus Finland, the case revolved around an incident where an unknown person placed an online advertisement using the name of the applicant, who was a 12-year-old child at the time, without his knowledge. This unauthorized use of his identity on the internet raised concern about privacy violation. The ACHR ruled that this act constituted a breach of the applicant's right to respect for private and family life as protected under Article 8 ECHR. So let's see other notable case pre-GDPR. So we have the Linkvist case, that is case C101/01, in which Bodil Lindqvist created a website where she posted information about church activities, including detail about some people that were performing the function, so some parishioners, name and contact info. The ACJ clarified that the act of referring various individuals on an internet page and identifying them by name, giving their telephone numbers or information about their working conditions and hobbies constitute processing personal data under the EU protection law, and this established that data protection laws apply not only to organizations and businesses, but also to individuals who process personal data in various contexts, including personal websites. Then there is, in 2006, we have ProMusica versus Telefónica de España, SAO, in case C 2075/06, in which a Spanish music copyright collecting society requested that Telefónica, a telecommunication company, disclose the identifies contact information of individuals suspected of engaging in copyright infringement by sharing music files online. The ACJ clarified that the EU member states were not obligated by the EU community law to require such disclosure. It emphasizes that EU members may choose to require such disclosure if they see fit, provided that such measures are in accordance with their own national laws and procedures. Second, it explained the fair balance doctrine, which between copyright protection and privacy rights. There is then Sabam versus Scarlett case. It is C710. Sabam was a Belgian copyright management organization that brought a case against Scarlett, an ISP in Belgium. Sabam alleged that Scarlett subscribers were using its network to engage in copyright infringement by sharing copyrighted music files without authorization. The ACJ ruled that the ESP, such as Scarlett, do not have a general obligation to actively monitor all data transmitted on their networks to prevent potential future infringements of intellectual property copyright violation. This means that the ESPs are not required, internet service providers are not required to proactively search for and prevent copyright infringement by their user. However, internet service providers are required to cooperate with right holders when specific infringements are brought to their attention, of course, under the proportionality umbrella. Then the Google Spain case, another very important, C131/12, in which Mario Costeja Gonzalez filed a complaint with the Spanish Data Protection Authority against the newspaper La Vanguardia and Google Spain and Google Inc. Google displayed the links to pages containing information about real estate action related to social security debts from 1998. The central issue addressed was whether Google qualified as a data controller under the EU Data Protection Directive 95/46. The SCA determined that Google did qualify as a data controller because it played a significant role in processing personal data regardless of whether it had knowledge of the data's content. The ECJ confirmed the existence of the right to be forgotten based on Article 12 of Data Protection Directive, which allows individuals to ask for erasure of personal data when it no longer meets the purposes for which it was collected. There is a balance between the right to be forgotten and the freedom of expression, hence there are cases where the public interest in access to information may override this right. The case underlined then that Article 9 of the same directive, which relates to exemption for processing personal data for journalistic, artistic, or literary purposes, does not apply to search engine providers. Digital Rights Ireland, case C293/12. The case dealt with the retention of telecommunication data for a period ranging from 6 months to 2 years for the purpose of investigating, detecting, and prosecuting serious crimes as defined by each EU member state and its national laws. The ECJ recognized that the retention of data required by the Directive 2006/24 constitutes a serious interference with privacy rights, and it recognizes the possibility of data retention, an objective of general interest. However, the concept of proportionality shall prevail, hence ECJ rules the 2006/44 EC directive to be invalid. That's the end of the updated data privacy directive that was in place at the time. And then the Schrems case, other very important. Max Schrems, an Austrian privacy activist, filed a complaint with the Irish Data Protection Commissioner, DPC, against Facebook Ireland, challenging the transfer of his personal data from the EU to the US, arguing that the US law and practices did not provide adequate protection for his data against surveillance by the US government authorities. The case questioned the validity of the EU Commission's decision 2000/520/EC, called the Safe Harbor Framework, which allowed for the transfer of personal data from the EU to the US companies that self-certify their compliance with certain data protection principles. Such decision invalidated the Safe Harbor Framework in October 2015. The Court of Justice of the European Union ruled that the US surveillance program, particularly those revealed by Edward Snowden, did not provide adequate safeguards for EU citizen personal data. The Court of Justice of the European Union clarified that the adequacy of data protection in a third country should be assessed in the context of the EU laws, as a third country must ensure a level of data protection that is essentially equivalent to that guarantee within the EU. Give me just a second, just a sec that I charge my laptop. Let's continue. Here it is, this one we talk. Okay. Tele2 Sverige, C203/15, in the Article 15 of the Directive 2002/58 allows member states to adopt legislative measures to restrict certain rights and obligations provided in the directive when such restriction necessary, appropriate, and proportionate to safeguard national security, defense, and the prevention, investigation, detention, and prosecution of criminal offenses. The ECJ hence concluded that in certain situations, access to data of person might be granted if there is objective evidence that the data could contribute effectively to combating such activity. However, ECJ prohibits member states to utilize Article 15(1) in the objective of access to such data. Is not restricted solely to serious crimes, lacks prior review by a court or other independent administrative authority, and does not require that the data be retained within the European Union. Ministerio Fiscal, C207/16. The central issue was the data retention practices in Spain, which allowed authorities to access retaining electronic communication data without prior review by an independent body. The ECJ had to evaluate if Directive 2002/58 EC the Privacy Directive, foreseeing this possibility and based itself on the principle of proportionality. The court indicated that national legislation must ensure that access to retained data is subject to adequate safeguard, including review by an independent authority, and that access should not go beyond what is necessary for its intended purposes. Now let's see the courts in the digital age. This one is part of the lectures we had. The judicial imagination is the ability of courts and judges to creatively interpret existing legal principles and adapt them to address novel and complex issues arising in the digital age. As is happening for data protection, right? Judicial reaction relates to how courts respond to specific cases of legal challenges in the digital age. Courts might react to technological developments by issuing rulings, interpretation, or judgments that set legal precedents. Judicial guidance, which involves the role of courts in providing clear and comprehensive interpretation of the law in the context of digital tech. Courts offer guidance through their decision, opinions, and legal reasoning. In the ECFR, several articles are dedicated to establish privacy and data protection. Article 7, right to private life, right to respect the private and family life, and Article 8, right to data protection, right to the protection of personal data, recognize the importance of safeguarding individual's personal data against unauthorized processing, ensuring data accuracy, and providing for the individual's right to access and rectify their data. The constitutional shift and the GDPR. So the shift from a market-oriented perspective to a human rights perspective in the cost of data management involves a significant change in how data is related and regulated. In a market-oriented approach, the focus is primarily on the free circulation of data, treating data as commodity that can be traded, analyzed, and used for economical purposes with few restrictions. On the other hand, a human rights perspective prioritizes the protection of personal data. This approach recognizes data privacy as a fundamental right and emphasizes the need to protect individuals' personal information from misuse, unauthorized access, and exploitation. It involves implementing stricter regulation and safeguards to ensure that data collection, processing, and sharing are done ethically and with respect for individual privacy and autonomy. This shift often leads to enactment of more robust data protection laws such as the GDPR in the EU, which give individuals greater control over their personal data and impose strict penalties on organizations that fail to comply with these regulations, reflecting a growing global recognition of the importance of privacy and the individual rights in the digital age. So from the Data Protection Directive, Directive 95/46/EC to the GDPR, this marks a significant evolution in data protection law within the EU. There are several key implications. Uniformity in Directive 95/46/EC, it provided a general framework and set out objectives that the EU member states were required to achieve. It allows states to choose. With GDPR, there is a directly applicable framework in all EU member states without the need for national transposing legislation. So there is a greater degree of uniformity. Lawfulness of processing, Article 6 Q of the GDPR. The GDPR sets a general standard to adapt the application of its particular in relation to processing for compliance with legal obligation or for tasks carried out in public interest or in the exercise of public authority and processing of personal data, that is Article 9(2)G. The GDPR allows exemption if the processing is necessary for reason of substantial public interest and is based on union member state laws, so there is the reaffirmation of proportionality. The General Data Protection Regulation is a comprehensive data protection law enacted by the European Union to safeguard the fundamental rights and freedoms of individuals concerning the processing of their personal data. The GDPR recognizes the fundamental right to privacy as enshrined in Article 8 of the European Charter of Human Rights, European Convention of Human Rights, and as part of the Convention on the Functioning of the European Union, which ensure that individuals have control over their personal data. Data subject rights. The GDPR empowers data subject individuals whose data is processed with various rights, including the right to access, rectify, erase, or object to the processing of the personal data, enhancing individuals' control over their data. GDPR lays down principles for the lawful processing of personal data, including transparency, lawfulness, fairness, and purpose limitation. Organizations must adhere to this principle to respect individuals' fundamental rights. Organizations are required to conduct a DPOA, so data protection impact assessment, when processing activities are likely to result in a high risk to data subject rights and freedoms. This assessment helps identify and mitigate potential risks. GDPR promotes a proactive approach to data protection by requiring organizations to implement protection measures from the outset by designing and to default to the highest level of data protection. GDPR sets strict standards for obtaining valid consent for data processing. Individuals must provide clear affirmative consent, and they have the right to withdraw consent at any time. GDPR mandates the notification of data breaches to both the supervisor, the authority, and affected individuals when the breach is likely to result in a risk to their rights and freedom. GDPR prohibits the transfer of personal data outside the EU or the European Economic Area to countries that do not ensure the adequate level of data protection unless specific safeguards are in place to protect individual rights. This prevents data from being sent to countries with lower data protection standards. Organizations are required to demonstrate compliance with GDPR through documentation and records of data processing activities. This accountability ensures that they protect individuals' rights and freedoms effectively. GDPR established an independent supervisory authority in a member state to enforce the regulation and protect individuals' rights. The main principle of the GDPR are enshrined in its Article 5, in which there is the transparency. Data subject must be informed about the trespassing of their data and its purposes. Information must be provided in a concise and transparent way, intelligible and easily accessible form, especially when addressing children. Individuals should be informed about any profiling and its consequences. Purpose limitation. Data should be collected only for explicit and legitimate purposes. If data is processed for purposes not compatible with the initial purpose, it requires renewed consent or statutory justification. Data minimization. Data should be relevant and limited to what is necessary for the purposes for which they are processed. These techniques, along with the privacy by design and by default, are encouraged to adhere to this principle. Excess or irrelevant data should be deleted promptly. Accuracy. Personal data should be accurate and kept up to date. Inaccurate data should be rectified or erased without delay. Storage limitation. Data should not be kept longer than necessary for the processing purposes. This ties with the right to erasure and the right to be forgotten. Integrity and confidentiality. Personal data must be processed securely. Protecting it against unauthorized and unlawful processing and accidental loss, destruction, or damage. Then, what are the key definitions? You have personal data, which are defined as any information related to identified or identifiable natural person, including publicly non-sensitive pseudonymy, IP addresses, tracking cookies, and localization data. Processing encompasses all operations performed on personal data, such as collecting, storing, disclosing, and erasing. Key actors are data subjects, individuals whose personal data are processed, data controllers, entities that determine the purpose and means of processing personal data, data processors, entities that handle data on behalf of controllers, data protection authorities that are regulatory bodies overseeing GDPR compliance. Ooh. GDPR exemption and right. Exemption are personal household activity, exempts data processing for purely personal or household activities. National security and law enforcement, national security and criminal offense prevention, prosecution largely outside the GDPR scope. Freedom of speech and expression, member states must balance data protection with freedom of speech, especially in academic, artistic, or literary context. The rights mentioned in the GDPR are the rights to access, the right to data portability, the right to rectification, the right to restrict the processing, the right to object, the right to erasure, or the right to be forgotten, and the right related to automated decision making and profiling. Article 2 and Article 3. In the GDPR, the scope of application of general data protection regulation is defined both materially and territorially in these articles. In Article 2, it is outlined how materially the scope is automated personal data processing, meaning any processing of personal data that is wholly or partly performed by automated means, and non-automated processing within a filing system. The processing of personal data that is not performed by automated means but forms part of or is intended to form part of a filing system. In Article 3, it is stated the establishment criterion processing activities of an EU established controller or processor regardless whether the processing occurs within the EU. This was notably reinforced in the Google Spain case, and the targeting criterion, which applies to non-EU established controllers or processors if their processing activities relate to offering goods or services to data subjects in the EU, regardless of whether the payment is required or monitoring the behavior of data subjects as long as the behavior takes place within the EU. It applies even to controller not established in the EU, but in a place where member states' national law applies by virtue of public international law. The GDPR and Article 6.1 outlines several legal bases for the lawful processing of personal data. Article 6. Consent. The data subject has given clear consent for processing their personal data for a specific purpose. Contractual necessity. Processing is necessary for the performance of a contract with the data subject or to take steps at their request before entering into a contract. Legal obligation. Processing is necessary for compliance with legal obligation to which the controller is subject. Public interest or official authority. Processing is necessary for the performance of a task carried out in the public interest or in the exercise of official authority vested in the controller. Vital interest. Processing is necessary for the legitimate interest pursued by the controller or a third party, except where such interests are overridden by interest of fundamental rights and freedom of the data subject. At Article 6.2 is explaining that the legitimate interest basis requires a balancing test between the controller's interest and the data subject right and freedoms. Factors to consider include the nature and origin of the legitimate interest, the impact on the data subject, and additional safeguards to minimize negative impacts. The data subject reasonable expectation based on their relationship with the data controller are a key factor. This leaves room for the data controller to evaluate what might be expected in a given context. The legitimate interest should not be seen as a last resort, but should be automatically chosen or unduly extended. It requires careful consideration. These bases can be used for purposes like fraud prevention, direct marketing, internal administrative data transfer within a business group, and assurance network and information security. Different legal bases can be used for multiple processing purposes, with each purpose needing to be legitimized by a specific legal basis. Article 4 and 7, this is the definition of controller. This article defines a controller as the entity that determines the purpose and means of the processing of personal data. Essentially, the controller decides why and how personal data should be processed. Article 4.8, definition of processor, defines a processor as an entity which processes personal data on behalf of the controller. The processor is responsible for handling the data as per the controller's instructions. GDPR at the Article 24 defines the data controller responsibility. So the responsibility and liability of the data controller indicated in Article 24, that the controller is responsible for any personal data processing carried out by itself or on its behalf. This includes ensuring that the processing activities comply with the GDPR. Controllers must consider the nature, scope, context, and purposes of the data processing, as well as assess the potential risk to the rights and freedoms of individuals. Controllers are required to implement measures that ensure and demonstrate compliance with the GDPR. These measures must be effective, suitable for the processing activity, undertaken and designed to mitigate identified risk. Controllers must not only comply with the GDPR, but also be able to demonstrate their compliance. This may involve maintaining detailed records of processing activity, conducting impact assessments, and implementing data processing policies. When designating data processing system or services, controllers need to integrate data protection features and setting that promote privacy and data security. This includes considering data protection in the early stage of product or service development. At Article 28 of the GDPR is described the data controller responsibility. So the Article 28 of the General Data Protection GDPR specifically addresses the responsibility and obligation of data processor. A data processor is any person, authority, agency, or other body which processes personal data on behalf of the data controller. Processor-controller relationship, there must be a legal contract or other legal act under the EU or member state law between the data processor and the data controller. This contract or legal act is binding on the processor with respect to the controller and lays out specific terms and conditions for data processing. The contract must specify the nature and purpose of the processing activities. It should clearly define the types of personal data to be processed. The duration for which the data will be processed must be stated, and the contract should also detail the rights and obligations of the controller. At Article 28, always there are other data controller responsibility as highlighted by the GDPR. The processor can only process data according to the controller's instruction, including transfer of personal data to a third country or an international organization unless required by law. Processors must ensure that persons authorized to process the personal data have committed themselves to confidentiality or are under an appropriate statutory obligation of confidentiality. Implement appropriate security measure in line with Article 32 of the GDPR and while engaging a sub-processor requires prior specific or general written authorization of the controller. If general authorization is given, the processor must inform the controller of any intended changes and give them the opportunity to object. Assist the controller is ensuring compliance with obligations concerning the security of processing, the notification of personal data breaches, and data protection impact assessment. At the choice of the controller, delete or return all personal data after the end of the provision of services and delete existing copy unless EU or member state law requires storage. Make available to the controller all information necessary to demonstrate compliance with the obligation laid down in Article 28 and allow for and contribute to audits, including inspection conducted by the controller or any other auditor mandated by the controller. At Article 32 that we mentioned before of the General Data Protection Regulation is centered on the security of the processing of personal data. It aligns with technical and organizational measures that must be taken to ensure a level of security appropriate to the risk associated with the data processing activity. The business must consider the risk presented by data processing, particularly from accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data transmitted, stored, or otherwise processed. The article suggests various types of measures that could be adopted, including but not limited to pseudo-anonymization and encryption. Systems and services that process personal data should be designed and operated with this key principle in mind. In case of a physical or technical incident, there should be a process to restore the data in a timely manner. The measures taken should be reviewed and updated regularly to ensure they remain effective. The level of security should be appropriate to the risk, taking into account the state of the art, the cost of implementation, the nature, scope, context, and purpose of processing, and the varying likelihood and severity for the rights and freedom of natural person. The controllers and processors are responsible for implementing this measure and must be able to demonstrate compliance. Article 32 advocates for a flexible, risk-based approach to data security, recognizing that not all data processing activities carry the same level of risk, emphasizes the importance of proactively addressing potential data security issues. The measure should be state-of-the-art, acknowledging that technology and risk evolve over time. The article strikes a balance between the severity of potential risk, the nature of the data being processed, and the practicality of cost of implementation security measures. Article 32 of the GDPR mandates the organization must implement appropriate technical and organizational measures to ensure a level of security appropriate to the risk of their data processing activity. These include processing data against unauthorized or unlawful processing and against accidental loss, destruction, or damage. It highlights the importance of a proactive and dynamic approach to data security tailored to the specific needs and risk for each data processing activity. At Article 35, that is the data protection impact assessment, I'm gonna take just a break now because I'm a little bit tired, but yeah, I'm gonna restart briefly. Okay, so let's return to the presentation. We were talking about Article 35, the data protection impact assessment, so the DPIA. On Article 35, there is an uncertainty about the nature of the risk, posing question about whether it pertains to high-risk data subject rights or the impact on data protection. Risk in GDPR is composed of an event and its consequences. This led to viewing GDPR risk in terms of compliance risk, where non-compliance is the event and its impact on data subject right is the consequence. The GDPR risk-based approach requires organizations to assess the impact of the data processing activity on the protection of personal data and the rights and freedoms of individuals. By doing so, organizations can identify potential risk and implement appropriate measures to mitigate damage to its compliance with GDPR requirements. Such article mentions risk factors like the use of new tech aspect of processing, nature, scope, context, purposes, and Article 35.3 provides specific examples of risk factors. PEA's privacy impact assessment and DPIA's data protection impact assessment differs, as the first are more comprehensive while the seconds are more focused, typically on data protection, compliance, and related impacts. The GDPR adopts a bottom-up approach focusing on data controllers' responsibility for balancing interest and ensuring data protection versus the IE Act, which instead takes a top-down approach with stricter control and limited discretion for providers and users of IE system, while DSA presents a hybrid model defining high-risk categories and compliance requirements but allowing for some discretion and enforcement. This regulation is gaining prominence in the EU, which had witnessed a shift from a bottom-up approach in the GDPR to a top-down approach as in the AI Act. The GDPR emphasizes fundamental rights as the guiding force for data controllers, with accountability is a key principle. This regulation allows significant discretion for data controllers in balancing organizational interest with protecting individuals' rights. In the DSA, there is a model ground with an intentional risk categorized, which is top down, followed by a secondary phase where private actors define specific right mitigation measures, and finally the AI Act marked a complete top-down approach with a redefined risk categories and limited discretion for AI system providers and risk mitigation, moving closer to a command and control model. Notable cases post the GDPR. Privacy International C623/17, the case questioning the legality of bulk data collection and storage carried out by UK intelligence agencies under national legislation. Such practice involves the indiscriminate collection of electronic communication data from a wide range of individuals, including those not suspected of any wrongdoing. The ECJ emphasizes the principle of proportionality and safeguards to individual rights in this case. Google versus CNIL C507/17. In the case, the CJEU held the right to be forgotten. The right to have certain search results delisted is not an absolute right and does not require global delisting of search results. Instead, it can be limited to EU territory. However, the CJEU also stated that the Google must ensure a balance between the right to be forgotten and the freedom of information and expression. It clarified that while not required to delist globally, Google must take measures to ensure that individuals' rights are effectively protected within the EU, including preventing access to the delisted information through all relevant domain name extension. Yes, Google is hence obliged to implement the listing request in an effective manner within the EU. This means that if a person's search results are delisted in the EU, Google must ensure that access to those delisted results is prevented regardless of the user's location within the EU. Schrems number 2, C311/18. In July, in response to Schrems' decision, the EU and the US negotiated a new framework called the EU-US Privacy Shield. However, in July 2020, the CJEU issued another significant ruling known as Schrems II, which invalidated the EU-US Privacy Shield, as the CJEU found that the US surveillance practices and lack of redress for EU citizens did not meet EU data protection standards. After this invalidation of the privacy shield, business had to rely on the alternative mechanisms such as standard contractual clauses or bilateral corporate rules, so BCRs, to transfer data from the EU to the US. La quadrature du net C5111/18. The central issue of this case was the data retention practices in France, which required electronic communication services provider to retain certain metadata about their user communications for purposes of national security and law enforcement. The ECJ considered whether the national legislation should require prior review by a court or an independent administrative authority before granting access to retained data. It also assessed whether access should be limited to the purpose of fighting serious crimes. Contemporary tech and data processing. The intersection of big data protection laws, particularly in the context of EU, present both challenges and opportunities. The concept of big data protection involves a multifaceted approach to managing and safeguarding vast quantities of data, often including personal data in compliance with data protection standards like the GDPR. Big data lacks a precise definition but generally refers to the large-scale collection, analysis, and use of data. It encompasses a range of technologies and practices, including cloud services and the Internet of Things, which are central to the EU digital economy and competitiveness. Not all big data raises data protection issues. Whether GDPR applies depends on whether the data is personal. The boundary between personal and non-personal data can be blurred, with many businesses handling mixed data sets. Anonymization can turn personal data into non-personal data, but this depends on the context and the controller's ability to re-identify individuals. Mostly big data within the EU data protection law. Transparency in big data is challenging but crucial. Individuals should be clearly informed about what data is processed, how and for what purposes. This includes understanding the logic behind algorithms used for assumption and prediction about individuals. Given the volume, velocity, and variety of big data, ensuring compliance with GDPR principles like data minimization and purpose limitation can be complex. Ensuring individuals' rights, such as the right to access, rectify, or erase their data, becomes more complicated with large, complex data sets. With the growings of machine learning and AI and big data analysis, there's a need for transparency in algorithm decision making. Accountability for automating decisions is a key requirement under the GDPR. Challenges posed by GDPR principle. The GDPR condition for legal grounds can be stringent, sometimes limiting or even prohibiting certain big data processing activities. In big data, the distinction between regular personal data and sensitive categories of data can fade, especially when different datasets are merged, leading to unintentional processing of sensitive data. Big data's inherent drive, collect, and retain as much data as possible for potential future users clashes with the principle of data administration. The GDPR requires that only data necessary for the specified purposes be collected and retained. Big data often involves collecting data from various sources, raising concern about relevance and accuracy of the data. The GDPR mandates that the data should be accurate and, when necessary, kept up to date. Okay. Big data's potential for future prediction relies on comparing current data with shared past data. This can conflict with the GDPR storage limitation principle, which requires that personal data not be kept longer than necessary for the purpose for which it is processed. The extensive processing involved in big data increases the risk of data breaches. The GDPR requires controllers to implement appropriate technical and organizational measures to ensure data security. In GDPR, the GDPR provides specific provision regarding automated decision made, including profiling, right of the data subject. Individuals have the right not to subject to decision based solely on automated processing, including profiling, that have a legal or similarly significant effect on them. This right does not apply if the decision is necessary for a contract authorized by law with suitable safeguard or based on explicit consent. The US approach on AI regulation categorized system based on risk and unacceptable, high risk and minimal risk. The classification regulation of these risks are directly managed by lawmakers, representing a shift to a more top-down regulatory approach. The categorization, particularly of high risk system, is adaptable, with the EU Commission having the authority to update and redefine these categories. The requirement for a risk management system is central, although there might be concerns about the extent of discretion left to providers and users. Judges privacy and data protection from atoms to bits across the Atlantic. The global flow of data across borders is crucial for the digital economy and public administration. Thus, however, represent constitutional challenges, as different legal regimes and jurisdictions are involved. Courts often have to decide on jurisdictional matters related to data in the digital dimensions, a role necessitated by the rapid pace of technological advancement. The right to privacy and data protection has undergone significant development, influenced by the emergence of welfare states and the information society, which increases the circulation of processing of personal data. In EU, the concept of personal data has become central to privacy protection, emphasizing the need for data processing in line with principles safeguarding personal identity. The US approach to privacy protection differs, focusing more on the societal impact of data processing rather than on individual data protection. Privacy and data protection do not enjoy uniform legal status globally. The rights are protected differently in various regimes, as illustrated by the contrast between EU and US framework. The US judicial protection for privacy rights has evolved significantly, particularly concerning Fourth Amendment protection against unreasonable searches and seizure. These evolutionary affects US Supreme Court's adaptation to new tech. The decision Olmstead versus US represents an early approach where wiretapped telephone conversations were not considered a violation of the Fourth or Fifth Amendments, since there was no physical intrusion. This approach was overturned in Katz versus US, where the Supreme Court recognized the Fourth Amendment protects people not just physical spaces. The concept that information exposed to the public is not protected under the Fourth Amendment emerged, emphasizing the reasonableness of privacy extension. Cases like Smith versus Maryland illustrate how tech advances affect privacy expectation. Here, the court held that the dial numbers recorded by a pen registered at the telephone company's office did not constitute a search under the Fourth Amendment. In obsession with the Katz decision, Mapp versus Ohio in 1961, the evidence obtaining a violation of the Fourth Amendment cannot be used in criminal trials. In 1965, Griswold versus Connecticut established a zone of privacy in the Constitution protecting individual autonomy and personal and familial decision, including the use of contraceptives. In 1977, the case Whalevin versus Rose, recognizing two types of privacy interest, decision-making autonomy, and the confidentiality of personal information. In 1978, the Foreign Intelligence Surveillance Act, FISA, established a separate legal regime for foreign intelligence surveillance with more lenient standards than domestic law enforcement surveillance. In the subsequent years, the Supreme Court adopted a more constrained view of what constitutes a reasonable expectation of privacy. Florida versus Raleigh in 1989 decided that no reasonable expectation of privacy is expected in a greenhouse visible from an helicopter. In California versus Greenberg in 1988 described that there is no reasonable exception of privacy in a garbage left in a car. But finally, in 1984, New Jersey versus TLO and in O'Connor versus Ortega in 1987, limited expectation of privacy in schools and government workplaces, allowing for search without traditional Fourth Amendment requirements. In the Telephone Consumer Protection Act of 1991, TCPA, individuals were allowed to request telemarketers to cease calls and sue for damages for non-compliance, almost a right to forget. The Drivers Protection Act, the PPA, instead aimed to require consent for sharing driver information details. From 2001, due to the terrorist attack on 9/11 and the entry into the game of the Patriot Act of surveillance, spyware were expanded, broadening definitions related to surveillance technology and allowed for more extensive sharing of intelligence information. The evolution of digital privacy in the EU judicial context is characterized by a progressive shift towards robust protection of personal data and privacy rights. This transformation has been influenced by pivotal cases in legislative development, with the CJEU playing a crucial role. The Directive 95/46 EC focused on data protection for the internal market, the EU's initial steps in harmonized data protection rules. The CJEU decision in the Linkvest case underscored the processing of personal data on the internet, balancing freedom of expression with privacy. This case reflected the CJEU's evolving view on privacy and data protection, highlighting the balance between property rights, effective judicial protection, and personal data privacy. The case ProMusiche reflected that the CJEU evolving view on privacy and data protection, highlighting the balance between property rights, effective judicial protection, and personal data privacy. The EU CFR adoption and its recognition on data protection, Article 8, as a fundamental right distinct to the right of privacy, Article 7, signified a pivotal shift. It marked the constitutionalization and increased the emphasis on data protection in the EU. The Digital Rights Ireland case is a landmark decision that invalidated the data retention directive for violating EU CFR rights. It demonstrated the CJEU's commitment to safeguarding digital privacy against wide-ranging state surveillance. Google's Spain case established the right to be forgotten, emphasizes the precedence of privacy rights over the right to information under the condition it represented a significant expansion of privacy rights in the digital domain. Schrems I case, in which the CJEU annulment of the safe harbor decision due to inadequate US data protection underscored the EU's rigorous standards for data privacy even when dealing with third countries. Zakharov versus Russia paralleled the CJEU's approach in Schrems I, emphasizing the risk to privacy rights posed by state surveillance, even in the absence of direct evidence of privacy breaches. The case and developments indicate a trend towards further judicial activism in protecting digital privacy. The CJEU and the ECTHR have shown a willingness to adopt legal frameworks and interpretation in response to technological changes and the challenges they pose to privacy and data protection. The Bosporus versus Ireland case, this implication, particularly in the context of Schrems I decision, highlights significant aspects of international law's interaction with EU law, especially regarding the protection of privacy and personal data. In the case, the EU court established a presumption that measures taken by EU member states in compliance with the EU law also comply with the EU Convention on Human Rights (ECHR) The ECTHR assumed that the EU legal system offers protection of fundamental rights equivalent to that of the ECHR, hence member states acting under EU law are presumed to comply with ECHR obligation. This presumption can be rebutted if the protection of rights under the ECHR is manifestly deficient in the specific context. The principle means that as long as EU law provides equivalent protection for fundamental rights as in the ECHR, member states implementing EU law are presumed to comply with their human rights obligation under the ECHR. The Bosphorus Doctrine implies that member states are generally not liable for violating the ECHR when acting in compliance with directly applicable EU law, as long as the EU system is considered to offer equivalent protection. However, in cases where the EU law does not leave any room for national discretion, the presumption of compliance can be rebutted if it is demonstrated that the protection under the EU law is insufficient compared to the ECHR standards. The Schrems I decision signified the evolving nature of data protection standards, especially in the international context. The CJEU and other European courts have significantly influenced the legal landscape of the Internet. Their rulings have expanded the scope of the EU legal principle, particularly in the realm of digital privacy and data protection, beyond the European borders. This process has led to a kind of judicial Europeanization of the Internet. The CJEU definition reflects an effort to regionalize the protection of digital rights, which might not align with the inherently transnational nature of the Internet. Balkanization of the Internet. The EU system has influenced other, but vice versa until now had not happened. The EU courts focus on protecting the digital privacy and personal data might have unintended consequences on their digital privacy and personal data might have unintended consequences on their fundamental rights, particularly freedom of expression. There is a concern that the EU court's approach could lead to an excessive Europeanization of the Internet regulation. And now, finally, we arrive to the part 2, and hence the last 50 slides. This one is pretty hard, so let's stay focused. That is the free speech online spaces. So let's start from the triangle and rise of the new school of free speech rights. Okay. So what is freedom of speech? The traditional justification for freedom of speech is rooted in democratic principle and the marketplace of ideas where open discourse is seen as essential for the discovery of truth, self-government, autonomy, and checking of power. This justification includes discovery of truth, the belief that through open debate and discussion the truth is more likely to be discovered, democracy, the idea that public participation in democratic processes requires the free flow of information and opinions, autonomy, respecting individuals' autonomy to form their own opinions and express themselves, check on power, allowing free speech act as check on government and other powerful entities preventing abuse of power. The term old school in this concept aims to refer to this traditional, perhaps idealistic justification for free speech, which have been with us since the Enlightenment period. Tech and social media had, however, introduced some challenges to these traditional values. Jack M. Balkin, in his essays, highlight a shift in the landscape of free expression from the 20th to the 21st century. It suggests that the earlier model, which was primarily concerned with government regulation of individual speech, is no longer adequate because it does not account for the complex dynamics of digital platforms and the Internet. The 20th century view of free expression was dyadic or dualist, with the two main actors being the states and the individual speaker. The 21st century model is pluralistic and with multiple layers, hence it becomes a triangle because the division between nation states and the EU, digital infrastructures, companies, speakers, and other actors. There are new problems arising in speech regulation. The modern configuration introduces challenges in terms of collateral censorship. Efforts by state to regulate speech online can lead to over-censorship by digital platforms seeking to avoid legal trouble. Actions like blocking websites or removing content before it's published could have chilling effect on free speech. Social media platforms exert considerable control over speech through their policies, and moderation practices often lacking transparency and due process. Users face privacy concerns and potential manipulation through data deletion and targeted content. Old school speech regulation versus new school speech regulation. The first characterized by direct state intervention such as fines and imprisonment to control speech, while the second aims to indirect regulation of the speech through the mediation of internet infrastructure companies, urging them to monitor policy and potentially restrict speech. Facebook, Twitter, and YouTube, which started as platform communication, have evolved into powerful governors of online spaces, creating internal bureaucracies and developing elaborate rules of manage the behavior of their user. These companies have taken on roles akin to authoritative states where they set and maintain order and standards, often with policies that lack transparency, to the user, as in autocratic states would report inefficiency and violation. They have no power over the policies. The vast use scale of interaction on this platform necessitates the use of bureaucracies and algorithms for content moderation. This system often require human moderation due to their efficiency and cost effectiveness, despite concerns over accountability and the nuances of human judgment. The governance of free speech on this platform is not a simple matter between the user and the platform. It involves societal norms. The triangle of free speech indicates the complex interplay between these three entities: platform, users, and society at large. Should private governance be private? While social media companies should recognize and protect free speech and due process value, applying First Amendment doctrines to them as if they were municipal governments would be problematic. First Amendment law limits how municipalities can regulate speech, such as anonymous speech, which might conflict with social media policies designed to prevent abuse like cyberbullying or hate speech. The degree of speech protection on social media platforms has been influenced by American values, but because the platforms are global, they cannot apply American values. But can apply American doctrines everywhere due to differing international tolerance level. Global social media companies require policies that can function across different legal and cultural contexts, hence why company like Facebook has worldwide policy that does not align with the American First Amendment protections. The privatized bureaucracy. The action discusses the complex interplay between nation states and private companies in the context of new school speech regulation on the internet. The new school speech regulation refers to how speech is regulated in the modern age, especially on digital platforms. Unlike traditional state censorship, new schools regulation involves private companies to manage digital infrastructure. The private governance, the essay points out that digital infrastructure companies such as social media platforms, search engines have developed their own system and bureaucracy to govern speech of their services. This company enforce their own terms of service, content moderation policies, and algorithms to monitor and regulate the content the user posts. The concept of private bureaucracy emerged from the reliance of nation states on private companies to perform certain regulatory function. Instead of the state directly censoring speech, private companies are deputized to carry out this action, effectively serving as private regulatory bodies. Protection of free speech values in this pluralist system of regulation. Solution to new tech challenges will likely not involve applying the exact test of the First Amendment to private companies. Instead, it recommends developing new approaches that align with free speech values but are tailored to the digital context where the First Amendment doesn't directly apply to the exact test of the First Amendment of private companies. Instead, it recommends developing new approaches that align with free speech values that are tailored digital contents where the First Amendment doesn't directly apply. The text outline two basic goals to protect free speech values in the new digital era. This involves addressing the issue of private companies potentially suppressing speech in ways that can have wider implications for censorship, addressing the concern about how private companies collect and use personal data, and how this can lead to surveillance and manipulation of individuals. There are four main problems: collateral censorship, privatized prior restraining, surveillance, and the manipulation. Permissible government regulation, structural reforms, and competition policies. Complexity of digital platform while maintaining free speech values. It poses certain types of regulation, such as structural and pro-competition regulation, can uphold free speech rather than constrain it. Structural regulation includes municipal broadband, open access rules for ISPs, and network neutrality. These do not enforce collateral censorship or digital prior restraint. Network neutrality in particular prevents ISPs from discriminating against content, which can help avoid censorship. Pro-competition regulation, the text suggests that antitrust law and media and antitrust media and legal constraint rules can foster competition and thereby suppress free speech. The argument is that more competitive landscape would have made the 2016 election interference less effective due to the diversification, resilience, and multiple of platforms can provide. Curators like Facebook and Google had a unique role because they organize and prioritize information for users. Their algorithms determine what is displayed and what order, which has a significant implication for what information people are exposed to and how they perceive the world. Because of this, the idea of content and viewpoint neutrality, which might be applicable to more passive service provider, does not easily apply to this platform, as neutrality is difficult to maintain when the platform's primary function is to sift through a vast amount of content to deliver what is deemed most relevant or engaging to the user. This decision could be based on complex algorithms and user data, which are proprietary and often not transparent to the end user or regulators. As such, the text suggests that we should think differently about the obligation of this company. This company talks on roles that are traditionally given to media outlets, their influence on public discourse, and their impact on the flow of information come with a set of responsibilities that are still being debated and defined. However, digital platforms have a greater control over the public discourse due to their technological capabilities and algorithms that filter and present information. Unlike traditional media, digital platforms have a duty to implement due process when moderating content because they have a larger user base that actively contributes to their content. This includes clear communication of policies, the right to be heard, and transparency in decision making. A guideline on how platforms should manage the removal of content are the Manila Principles, as they emphasize transparency and fairness in the process. However, requiring digital curators to provide due process wouldn't necessarily infringe on First Amendment rights, and propose leveraging Section 230 of the Telecommunication Act to encourage platform to adopt due process principle by amending Section 230 to create a safe harbor provision that rewards digital curators for adopting due process principle. Platforms can maintain their intermediary immunity, safe harbor. The role of digital curator isn't just about choosing content for users, but also about suing the information about user to influence and control their behavior. This position of power can lead to a governance-like role of the user. US versus Europe jurisdictions in comparison. The U.S. approach, the First Amendment of the U.S. Constitution, is one of the cornerstone principles of the American legal doctrine, providing a robust defense of free speech that is considered among the most protective in the world. The U.S. Supreme Court, however, does not interpret this as an absolutist view. However, there is a very strong presumption against any law that limits speech. One of the principles that have emerged in the First Amendment jurisprudence is the concept of content neutrality. The government generally cannot restrict speech simply because it dislikes the ideas being expressed. If a law targets speech based on its content, what the speech means, it's considered to be content-based and is subject to strict scrutiny. The most stringent standard of judicial review. Under such scrutiny, a content-based restriction of speech is unconstitutional unless the government can prove that the restriction serves important state interest, one of the utmost importance. The restriction is narrowly tailored to achieve that interest. It doesn't overreach or restrict more speech than necessary. There are less restrictive means available to achieve that interest. It's the least restrictive way to accomplish the government's objective. Despite the strong protection, not all speech is free from regulation. The U.S. Supreme Court has recognized specific and narrowly defined categories of speech that are considered outside the bound of the First Amendment protection. These include the true threats statements, where the means to communicate a serious there is a mean to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group, incitement to imminent lawless action, speech that is directed to incite or producing imminent lawless action and is likely to incite or produce such action, Brandenburg versus Ohio in 1969, obscenity, that defined by the Miller test, Miller versus California in 1973, which assess whether the work depicts sexual conduct in a potentially offensive way, whether the work lacks serious literary, artistic, political or scientific value, and whether the work appeals to the prominent interest, all as determined by the community standards. So let's see them in details with the notable case. So we talk about Brandenburg versus Ohio in 1969, a case in which the U.S. Supreme Court established a specific standard for laws that criminalize speech as incitement for violence. The case revolved around the Ku Klux Klan leader who was convicted under an Ohio criminal syndicalism law, which made it illegal to crime, sabotage, violence, or unlawful methods of terrorism as mean of accomplishing industrial or political reform, as well as to assemble with any group formed to teach or advocate the doctrine of criminal syndicalism. The Ku Klux Klan made promotion of necessity of violence or vengeance against politicians and African Americans if the government continued to suppress the white Caucasian race. The Supreme Court unanimous decision in 1969 overturned Brandenburg's conviction, ruling that the Ohio law was overly broad and unconstitutional. The government cannot constitutionally punish abstract advocacy of force or law violation, and introduce a Brandenburg test which has two prongs: intent. The speech must be directed to inciting or producing imminent lawless action. This means that the speaker must have a subjective intention to promote real-world violence or illegality, not merely express an idea or teach some abstract doctrine. Imminence, the speech must be likely to incite or produce such actions. This imminence requirement means that the advocate violence or law-breaking must be expected to occur or be urged to occur incidentally or amongst others, no direct or no immediate means the prong is not met. The other important case that we quoted before is Miller versus California in 1973. It's another pivotal case in the history of the U.S. Supreme Court's First Amendment jurisprudence, particularly in the context of obscenity, which is to protect by the First Amendment. The case originated that Marvin Miller, operating a mail-order business, conducted a mass mailing campaign to advertise the sale of illustrated books categorized as adult material. Miller was then convicted of violating California obscenities law. The Supreme Court reaffirmed that obscene material is not protected by the First Amendment and established the Miller test, which had 3 prongs used to determine whether material is obscene and 2 subject to regulation or criminal sanction. So the first prong is whether the average person applying contemporary community standards would find the work taken as whole appears to the prevalent interest, meaning an erotic, lascivious, abnormal, unhealthy, degrading, or shameful interest in particular. Whether the work, then the second prong is whether the work depicts or desire in apparently offensive way sexual conduct or excretory function specifically defined by applicable state law. These complementary of the test allows locality some discretion defining what is offensive, reflecting the court's recognition that what is obscene in one place may not be considered so in another. Whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. This part of the test is sometimes referred as the SLAPS test. SLAPS test, the serious literary, artistic, political, scientific value, is the third part of the 3-pronged Miller test for determining obscenity as established by the US Supreme Court. The following consideration are part of the test. National standards. The SLAPS test is applied based on a national standard perspective, whether it could have serious value on a national as a whole. Not taken in isolation, the work must be considered as a whole. Objective assessment. The test is intended to be applied in an objective manner, even if the creator of the work subjectively intended no serious value. If the work can be perceived by a reasonable person to have literary, artistic, political, scientific value, it should not be found to be obscene. Expert testimony. An art critic can be called to bring his experience, nature of the work, historical and cultural contents, and the contents relevant, and public perception. Though SLAP test is not based on a majority approval, a work that has been widely accepted or critically acclaimed is more likely to be seen as having serious value. Now let's see another case. That is Kenneth Zerani, America Online, Inc. in 1994. Zaran was an Oklahoma resident who in 1995 became victim of a cruel prank when an unidentified person posted a message on American Online bulletin board advertising a slogan t-shirt that made light of the recent Oklahoma City bombing. The message included Zaran's home phone number. The legal issues at the heart of the case was whether American Online could be held liable for the defamatory content of what was posted by its user, as Zaran claimed it did not do enough control on defamatory messages and was notified to them as traditional negligence standards. The court ruled in favor of American Online, based largely on the protection afforded by Section 230 of the Communication Decency Act (CDA) of 1996, which states that no provider or users of an interactive computer service shall be traced as the publisher or speaker of any information provided by another information content provider. As the case affirmed, a broad immunity granted to online providers under Section 230, which has since been a cornerstone of how the internet operates, allowing platforms like Facebook, Twitter, and countless others to host user-generated content without bearing the risk associated with publisher liability. In US, what are the standard reasons for freedom of expression? Freedom of expression is considered essential for democracy. Citizens need to be informed and able to freely exchange ideas and criticism concerning public governance. It's posited that the free flow of information and ideas allows for the discovery of truth through the marketplace of ideas. Freedom of expression is crucial for individual self-fulfillment and dignity. It supports personal growth, autonomy, and the development of individual identity. Free speech then acts as a check on government power by allowing citizens to critique and hold their government accountable. New York Times versus Sullivan reinvigorated this justification by emphasizing the importance of free speech and press in the context of public discourse, especially when it involves criticism of a public official on their conduct. The case established the rational principle of the First Amendment protect open and robust debate on public issues when such debate includes harsh criticism of those in power. Section 230 of the Communication Decency Act, CDA, is a piece of internal legislation in the US passed in 1996 that provides immunity for websites and publishers from third-party content. Section 230C, often referred as the Good Samaritan Clause, is particularly crucial as it underpins much of how much the modern internet operates, specifically with regard to content moderation and user-generated content. Section 230C1 provides that no provider or user of an interactive computer service shall be considered the publisher or the speaker of information provided by another information content provider, and online services are not legally responsible for the content that the user posts. Section 230C2, civil liability. Two cases in which the online services providers are protected in case of civil liability. First, when they take action in good faith to restrict the access to or availability of material that they consider to be objectionable. This gives providers a broad discretion to remove content they find inappropriate without facing legal expression for these legal provisions for these moderation activities. When they take action to provide the second case is when they take action to provide the technical means to restrict access to material that is objectionable. This implies that if a service provider gives users tools to find the existence of that content on their platform or effectiveness of the tool provider. Now let's start with the EU approach, but I think we can stop here for the moment and we return in a bit. So let's return to our presentation. I hope I will be brief. I don't think so though. So what is instead the EU approach? The EU approach is embodied in Article 10 of the EU Convention on Human Rights that recognizes the fundamental rights to free expression, but also explicitly acknowledges the right comes with duty and responsibility and may be subject to certain restrictions. Free speech in this way is balanced against other rights such as the right to privacy, the right to good reputation and public order. The principle of proportionality imposes restriction on speech must be proportional to the legitimate aim pursued, meaning that they must appropriate, necessary in a democratic society, and not excessively burdensome. Many EU countries have laws against hate speech that would be unconstitutional in the US. The EU tends to give more weight to personal privacy and reputation, allowing broader restriction on speech to protect this interest, right to be forgotten. Of course, may consider the speaker's intent, the value of the speech, the public discourse, and the manner in which speech was disseminated. The EU is more willing to limit speech to prevent disorder or crime, whereas the US requires accurate, present, or imminent lawless action. Now let's see Facebook as an example of online governance. So, when online speech, from postal traps to proportionality and probability, the challenges and complexities that large social media platforms face regarding content moderation, using the specific case of Musk ad bans during the COVID-19 pandemic as an example. Facebook's attempt to prevent the exploitation of the public health crisis led to unintended consequences such as hindering volunteer efforts to distribute homemade masks and inadvertently allowing scammers to profit by slipping through the moderation system. This dynamic underlines the core difficulty in content moderation, the reliance on authoritative sources that may themselves be slow to adapt to emerging scientific consensus or may provide guidance to become contentious. The First Amendment system could be no longer viable for online speech. It underlines a shift from a framework that was prioritizing individual online speech rights toward a more systemic approach that considers broader societal interest and the practicalities of moderating at scale. This new approach emphasized two main principles: proportionality, which suggests that actions taken to moderate content should appropriate to the severity of the issue, and that involve significant actions require stronger justification. The notion of proportionality has deep roots in constitutional law and is employed in various legal systems as a way to ensure that any limitation or rights are justified by corresponding societal need. Probability refers to the acknowledgement and management of error rates that come with enforcing rules of a vast scale. No system can be perfect, especially when moderating millions of pieces of content, and this principle recognizes the practical reality that decisions must be made under uncertainty and with imperfect information. The evolving nature of online speech governance and content moderation on internet platforms. 2. Facebook acknowledging the complexity of online interaction has moved from prioritizing the goal of connecting people or recognizing the need to limit voice for authenticity, safety, privacy, and dignity. This reflects a shift from a more absolute view of free expression to a nuanced approach that considers other values and the potential harm from unfettered speech. Both Facebook and Twitter acknowledgement that content moderation cannot be perfect due to the sheer volume of online content and the composition of speech. The process of rule formation for online speech is crucial for legitimacy and public acceptance. The discussion points out that any regulatory reform, particularly potential changes to Section 230 of the Communication Decision the Ads, need to be informed any practical realities of content moderation. Early online speech governance was guided by a method akin to Ronald Dworkin's conception of right as trumps, meaning individual speech rights were paramount, the post must flow. Initially, there was a high regard for freedom of expression online, and platforms generally allowed users to post what they wanted. This perspective is highlighted by Facebook's executive statement, emphasizing the deep belief in connecting people, implying that any means facilitating this connection was seen as inherently good. The first decade of the internet saw a laissez-faire approach by online intermediaries regarding user-generated content. Jonathan Zittrain refers to this period as the rights era of internet governance, characterized by a libertarian ethos where speech was largely unregulated and intermediaries were never interfered. This framework began to strain as platforms faced increased regulatory and societal pressure to consider interests other than the individual speech rights. This led to a rise in content moderation that considered proportionality weighing individual speech rights against other important interests. As major tech platforms grew in scale, the individualistic approach to speech adjudication became unmanageable, necessitating a more systemic and probabilistic approach to governance. This implies a shift towards methods that consider broader patterns and probabilities rather than case-by-case decisions. The evolution of content moderation now includes proportionality and probability. This new paradigm is seen as necessary for realistic and sustainable platform governance. It has become clear that digital platforms cannot remain neutral, especially in how they present content to the user. The categorization of speech, which follows the categorical approach by the First Amendment, in which speech is classified into protected and non-protected categories rather than engaging in a balancing of interest, involves inherently a judgment. There has been a change in how society views speech and the inherent with increasing recognition that not all speech is equal and some may be harmful or require regulation. The numerous categories used by platforms for content moderation are often inconsistent and lack coherence, leading to calls for a more principled approach like proportionality. In recent years, the unshakable commitment to the principle that more speech is the best antidote to harmful speech has come under scrutiny. Public opinion, legal perceivers, and platform policies have shifted towards acknowledging that undeterred freedom of expression online can have dire consequences. Platforms like Facebook, Twitter, and YouTube found themselves at the center of controversies involving serious society harms, including genocide, election interference, and terrorist attacks. This has led to a re-evaluation and implementation of more stringent hate speech policies. Such actions represent a move away from the purely American First Amendment absolutism towards a more balanced approach, commonly found in other legal systems, which aims to mitigate the harms of toxic speech while upholding the principle of free expression. The overall narrative is about finding the right balance between protecting free speech and preventing harm. It points to a growing consensus that the harm of certain speech on the internet are significant enough to justify more proactive regulation and moderation by online platforms. A stance that aligns more closely with international perspective on hate speech and freedom of expression, the proportionality principles. Proportionality recognizes a spectrum of interest beyond just the individual right to free speech. The argument against proportionality is that it lacks the predictability and uniformity of categorical rules. Proportionality strength in its contextual application, avoiding absolute rule hierarchies. Proportionality allows for the consideration of various interests and contexts, giving a more legitimate perception of decision-making processes. It advocates for transparent value judgment decision, contrasting with the often opaque categorization methods. It allows for nuanced remedies and content moderation beyond the binary take down, leave up approach. The process of balancing different interests such as free speech against other societal values is inherently subjective and complex. In the private context of platform, determining what constitutes a legitimate reason for limiting speech is challenging. Like governments, platforms may lack the necessary expertise and legitimacy to assess the weight of different interests, especially in issues like public health or community morals that vary widely across cultures and geographies. Platforms have to make decisions about content moderation without established legal doctrines, making them to be arbitrary of public disclosure. Given the complex technical and dynamic nature of online speech, mandate of transparency is necessary to ensure platforms are accountable for their content moderation practices. And such mandates should be scalable beside on a platform size to avoid shifting competition. Regulation of content and content providers then. US perspective, Section 230 of the Communication Decency Act, CDA, as discussed in Zeran versus Awal case. Section 230 provides immunity to online service providers from being treated as the publisher of information provided by third-party users, and this has been the cornerstone of content regulation in the US, fostering a hands-off approach to moderation by not holding platforms legally responsible for using generated content. The First Amendment of the US Constitution provides robust protection for free speech, limiting the government's ability to censor or restrict content except in extreme circumstances such as incitement to imminent violence or child pornography. Platforms in the US generally engage in voluntary content moderation based in their terms of service, community guidelines, and company policies. While in the EU perspective, although primarily interested with data protection, GDPR has implications for content moderation too, particularly around the right to be for content, which can require platforms to remove personal data upon request. The DSA and the DMA proposed the EU regulation aimed to standardize content moderation, increase transparency, and ensure that platforms are held accountable for systemic rights posed by their services. The directive AVMSD, this directive includes provision for the regulation of video sharing platform, focusing on issues like hate speech and content harmful to minors. Content moderation is subject to more stringent and detailed regulation, which can require platforms to remove illegal contents expeditiously or face penalties. Now let's do a comparative analysis. The US prioritizes free speech, sometimes even over privacy concern, whereas Europe tends to balance free speech with privacy and dignity rights. The EU model allows for more government involvement in content regulation, whereas the US model relies more on self-regulatory platforms. US platforms are generally shielded from liability for user-generated content, while European platforms can face greater risk of legal liability for failing to comply with content regulation duties. Both in the US and the EU, the use of algorithms and automated systems to regulate can result in collateral censorship. However, the EU push for algorithm accountability might lead to different approaches to mitigate such outcomes. In the US, content moderation is largely at the discretion of the platforms themselves through terms of services and community guidelines. Company policy and discretion in enforcement, as platform has freedom to decide not only what content is allowed, but also how to enforce their rules. Algorithms are designed based on machine and AI. They are trained on vast datasets to recognize patterns that correspond to platform use. Despite their sophistication, algorithms can make mistakes. This can lead to collateral censorship, where legitimate content is mistakenly flagged and suppressed. This is a significant challenge because it can stifle free expression and harm users whose content is wrongly censored. In the EU, content moderation is not just a matter of platform policy, but also of compliance with local laws and regulation. Unlike the mostly voluntary system in the US, European platforms are often legally required to remove certain types of content. This content can include hate speech, incitement to violence, and terrorist propaganda. Failure to comply can result in hefty fines or other legal penalties. Regulation often mandates specific time frames within which content must be assessed and potentially removed. This is designed to prevent the spread of harmful contents, but it puts pressure on platforms to act quickly, sometimes at the expense of careful deliberation. In Germany, NetzDG law is one of the most talked about models of content regulation, which requires social media companies to remove or block access to manifestly unlawful content within 44 hours of receiving a user complaint. The law applies to any platform with more than 2 million registered users in Germany, which includes most major social media companies. NetzDG has been both praised for its attempt to curtail online abuse and criticized for potentially stifling free speech and for the burden it places on platforms to make complex legal judgments swiftly. Now let's see more in detail the EU Digital Service Act, the DSA, in terms of content-related issue. So the DSA is a significant piece of legislation proposed by the EU Commission that aims to modernize the regulatory framework for digital service actors in the EU. The DSA propose further accountability on online platforms that reach more than 10% of the EU's population, conduct risk assessment, identify potential harmful impacts of their services, and take mitigating steps. Under the DSA, notice and action mechanism will be standardized, ensuring that platforms have clear procedures for users to flag illegal content. Clear timelines will need to be indicated by platform to respond to notification of illegal content. The DSA includes measures to protect the fundamental rights of users, such has right to redress. User will have the right to challenge platform contents moderation decision, ensuring a human review of automated decision and transparency reports. Platforms will have to provide detailed reports on content moderation action, including the number of orders received from authorities. For platforms classified as very large online platforms, it must assess systemic risk associated with the use of their services, including the dissemination of illegal content and negative effects on fundamental rights. Very large online platform must submit to independent audits of the risk management system and must provide vetted research with access to data to understand how risk evolve. While the DSA does not directly regulate content deemed harmful but not illegal and encourage the platforms to develop voluntary codes and collaborative with fact checkers. Illegal content on the DSA. The DSA broadly defines illegal content to reflect offline rules encompassing information that is illegal in itself, like hate speech or terrorist content, or that pertains to illegal activities like selling counterfeit products. It excludes material like eyewitness video of crimes, providers deliberately involved in illegal activities such as facilitating illegal action cannot benefit from liability exemption under the DSA. So, the Article 1, the DSA outlined the subject matter and objectives of the regulation. The DSA aims to enhance the functioning of the internal market for intermediary services, ensuring that online platforms and services operate efficiently across the EU. Three main pillars are indicated in the Article 1. Section 2. Framework for conditional exemption from liability. This framework outlines the condition under which providers of intermediary services are not held liable for the content their user post. Due diligence obligation. The DSA imposes specific due diligence obligation on providers of intermediary services, which vary depending on the type and size of the service provider. And then in flag and enforcement rule, the DSA details how the regulation will be implementation and enforcement rule. The DSA details how the regulation will be implemented and enforced, including the cooperation and coordination between the competent national authorities within the EU. At Article 2, the DSA explained that it applies to all intermediary services offered to users who are established or located within the EU, regardless of where the company providing these services is established, while services that do not qualify as intermediary services are not covered by the DSA. Intermediary are online platforms, internet service provider, and cloud services that store or disseminate information on behalf of the users. The DSA at the Article 8 stipulates that providers of intermediary services such as social media platforms, online marketplace, and ESPs are not required to monitor all the information they transmit or store actively. They are also not required to proactively seek out illegal activities. This means that while they must act when they become aware of illegal content, they are not under an obligation to constantly search the platforms for such content. At Article 9, established when a service provider receives a legal order from national authorities to take action against specific illegal content, it must promptly inform the issuing authority about the action taken in response to the order. The order must clearly state its legal basis, explain why the content is considered illegal, and provide information identifying the issuing authority, and must provide clear details such as the URL. If another authority is to be informed about the action taken, it must specify the order's territorial scope, should limit to what is necessary to achieve its objective. The Digital Service Coordinator who receives the order must then share it with other digital service coordination across the EU without delay. The service provider must inform the content poster about the order, including the reasoning, order expectation, and the territorial scope of the order. Either when action is taken or as being specified by the issuing authority. Article 14 explains that intermediary services provider must include in their terms and conditions detailed information about any restriction they impose on user-provided content. This includes their content moderation policies, procedures, measures, and tools, including algorithms and human review processes, as well as rules governing their internal complaint handling system. The information should be clear, intelligible, and user-friendly, and unambiguous, and should be publicly accessible in a machine-readable format. If a service primarily targets or it is predominantly used by minors, the provider must explain the usage condition and restriction in a manner understandable to minors. Provider must apply and enforce the terms and conditions in a diligent, objective, and proportionate manner, respecting the rights and interests of all parties, including fundamental rights like freedom of expression. Very large online platform search engine must provide a concise, easable, accessible summary of the terms and conditions, including remedies and redress mechanisms in clear language. Article 15, Gesù. Article 15 explains that providers of intermediary services must publish annual, easily understandable reports on their content moderation activities. Such reports should include the number of orders received from authorities, categorized by types of illegal content issued in member states, and media response time. For hosting services, detail on the number of notices received, action taken, as use of automated tools, and response time. Information on content moderation initiatives by the providers themselves, including the SUE of automated tools, ranging for content moderators, the number and type of measure affecting content, visibility, and accessibility. Details on the use of automated means for content moderation, including purposes, accuracies, error rates, and safeguards. Article 16, instead of the DSA, explains that providers of hosting services are required to implement mechanism that allows individual entities to notify them of specific information considered illegal content on their user. This mechanism must be easily accessible, user-friendly, and support electronic submission. The notice mechanism should facilitate the submission of detailed and substantiated notices, including a substantiated explanation of why the consent is considered illegal, clear indication of the consent location, such as exact URL, the notifier's name and email address, except for certain offenses under Directive 2011/93/EU, a statement confirming the notifier's bona fide belief in the accuracy of the information provided. The provider should confirm the receipt of the notice of the notifier if electronic contract information is provided. Providers must process notices and make decisions regarding reported content in a timely, diligent, and non-arbitrary manner. This is in Article 17. Article 17 explains that providers of hosting services must provide a clear and specific statement of reason to affected user for any restriction imposed on their content, including removal, demotion, suspension, or termination related to illegal content or terms and conditions related. The statement must include the type of restriction imposed and its scope and duration, the facts and circumstances leading the decision, including the notifier's identity if necessary, information on any use of automated decision-making, legal grounds for considering the content illegal or incompatible with terms and conditions, information on available redress mechanism, including legal complaints, out-of-court settlement, and the judicial redress. Information provided must be clear, comprehensible, precise, and specific to enable effective exercise of redress. This does not apply to orders from authorities to act against illegal content. Article 20, instead of the DSA, outlines the requirements for an internal complaint handling system that providers of online platforms must implement. This system is designed to enable service recipients, including those who have submitted a notice, to lodge complaints against the platform's content moderation decision. The system in this way allows users to file complaints electronically and free of charge against decisions related to removal or restriction of content visibility, suspension or termination of service provision, account suspension or termination, restriction or monetization of content. This 6-month period for accessing the complaint system begins from the day the user is informed about the content moderation decision, as outlined in Article 16.5 at Article 17. Article 21 explains that users affected by content moderation decision have the right to access certified out-of-court dispute settlement bodies to resolve disputes related to this decision. Both parties are expected to engage in if the dispute has already been resolved. Dispute settlement bodies must be certified by the Digital Service Coordinator and meet specific conditions, including impartiality, expertise, and efficient dispute resolution. If the dispute is decided in favor of the service recipient, the platform bears all fees charged by settlements body should be reasonable. Article 34 established that very large platforms and search engines must diligently identify, analyze, and assess systemic risks stemming from their service design, functioning, and usage. The scope of risk assessment at these main aims to include risks like the spread of illegal content, negative effect on fundamental rights, civic discourse, public security, and physical and mental well-being. Providers must assess how factors like recommender system, content moderation, terms and conditions, advertisement system, and data practices influence the risk. Specific regional or linguistic aspects should be considered. Article 35. Providers must implement reasonable, proportionate, and effective measures tailored to identify the risk, considering the impact on fundamental rights. Measures may include adapting service design, content moderation process, algorithm system, advertising system, etc. The board, in cooperation with the Commission, publishes annual comprehensive report identifying systemic risks and best practices for mitigation. The Commission may issue guidelines for specific risks, presenting best practices and recommending measures considering the impact on the fundamental rights. Now we have seen what is the European debate, what is the European evolution, and we jump on the US debate instead of the duties of social media, because as we say are completely different from the one for the EU. So in that case, the debate in the US regarding the duties of social media platforms primarily revolves around content moderation, free speech, user privacy, misinformation, and the legal framework governing these platforms, notably Section 230 of the Communications Decency Act. In the US, where free speech is a constitutional right, there is a significant debate about the extent to which social media platforms should moderate content. Critics argue that excessive moderation infringes on free speech, while proponents argue that some moderation is necessary to prevent harm. Since social media platforms are private entities, they are not subject to the First Amendment in the same way as public institutions. This distinction fuels debate over these platforms can or should control speech. Section 230 provides immunity to online platforms from liability for user-generated content. This is central to the debate as it allows platforms to host user content without being legally responsible for it. The global reach of the US-based social media platform places a spotlight in their notion of responsibility and the need to respect the cultural and legal norms of different countries. Issues like hate speech, terrorism, and child protection require cross-border cooperation and pose complex jurisdictional challenges. Some advocate for the industry to develop self-regulatory practices such as clear content policy and transparent reporting. Others call for more government regulation and oversight, arguing that self-regulation is insufficient to address the scale of the issues. Now let's see two main cases in this regard, and you're gonna see how much these are two cases related to two laws. Okay, one is from the SB 1072 and the other HB 72. I think HB 72, we're gonna see them. One is a Florida law and the other is a Texas law. Both of them, they have some ideas that actually we have seen in the DSA. In the DSA, these ideas are unquestioned, while in the US, these ideas are inside a big debate about the whole thing. In 2021, Florida passed a law, the Senate Bill 7072, which aimed to limit how social media platforms can moderate content. The law partly as in response to claims that these platforms were censoring conservative viewpoints, Key provision of the law included fines for the platform, political candidates, and requirements for consistent application of content moderation standards. NetChoice, representing some tech companies, argued that such law infringed the First Amendment of the US Constitution and precisely their editorial rights. Initially, the U.S. District Court of Florida granted a preliminary injunction against the enforcement of the law, agreeing that it likely violated the First Amendment. The court held that the law's provisions on content moderation were a form of compelled speech and impossible burden the platform's editorial judgment. At this point, the case Packingham vs. North Carolina was a significant case decided by the United States Supreme Court on June 19, 2017. The case revolves around the First Amendment and its application to social media access for registered sex offender. Lester Gerald Packingham, a registered sex offender in North Carolina, was convicted for posting on Facebook, which was a violation of a North Carolina law. This law made it a felony for registered sex offenders to access certain websites, including social media platforms like Facebook and Twitter, where minors can create accounts. Packingham initially challenged this law as violating the First Amendment. However, his motion was denied by a North Carolina Superior Court, and he was convicted. The North Carolina Court of Appeals later revised this decision, holding that the law was too broad and violated the First Amendment, as it restricted access to a wide array of internet activities unrelated to protecting minors from sexual abuse. The U.S. Supreme Court unanimously reversed the North Carolina Supreme Court's decision, ruling in favor of Packingham. Judge Anthony Kennedy, who authored the majority opinion, emphasizes that the First Amendment assures everyone's access to places where they can speak and listen, including cyberspace and social media. The court recognizes that social media platforms are akin to modern public square, vital for communication on a wide array of topics. By barring sex offenders from these platforms, the law, according to the court, prohibits access to what for many are the principal source for current events, job searches, and the vast realms of human thought and knowledge. Judge Samuel Alito agreed that the specific law violated the First Amendment, but noted that there could be scenarios where legal restrictions on sex offenders regarding certain websites might be reasonable. This case was significant in addressing the role of the First Amendment in relation to social media use. It underscored the importance of internet platforms in exercising free speech and expression in the digital age. The decision has been cited in other cases challenging a similar restriction and has influenced how laws affecting internet use and free speech are viewed, particularly regarding government regulation and the balance between public safety and individual rights. This case marked a pivotal moment in understanding the intersection of digital spaces and constitutional rights, particularly highlighting the evolving nature of freedom of expression in the internet era. Now we have NetChoice versus Florida, Courts of Appeal, in 11 Circuit 2003. Central to the case that we mentioned above, the government could appeal social media platform to host speech they would otherwise moderate or remove. The platform argued that content moderation was a form of editorial discretion protected under the First Amendment. Florida argued that social media platforms function as a common carrier or public accommodation, similar to utilities or hotels, and therefore could be subject to non-discrimination requirements. This argument was contested by the platforms, which saw themselves as private entities with the right to control their content. The case touched on broader themes about the extent to which the government can regulate online platforms, especially given the growing public discourse. The court addressed the constitutionality of a Florida law that sought to regulate content moderation practices of social media companies' platform. The key issue revolves around the First Amendment rights of social media companies and state abilities to control their content moderation activity. The court held that the social media companies such as Facebook and Twitter are private actors whose rights are protected under the First Amendment. This means that they have the freedom to control the content on their platforms without undue government interference. The court found that content moderation decisions by these platforms are a form of editorial judgment and thus are protected under the First Amendment. The court ruled that certain provisions on the Florida law, in particular those restricting the platform's ability to moderate content and platforms' political candidates, are likely unconstitutional as they unduly burden the platform's editorial discretion. The law requirement to provide a sound rationale for every content moderation decision was also deemed likely unconstitutional as it imposes an onerous burden on the platforms. The court finally disagreed with the interpretation of social platforms as common carriers because they do not act like traditional common carriers as they make individualized decisions on content, are distinguished from carriers in Supreme Court precedents and federal laws, have editorial discretion protected by the First Amendment unlike common carriers. NetChoice versus Paxton, Fifth Court of Appeal of Texas. This case was significant in the broader context of legal and political debates over the regulation of large social media companies and the content of their responsibility and rights under the First Amendment, especially regarding content moderation and free speech. The HB 20 was a Texas law aiming to restrict the ability of social media platforms to remove or restrict user consent based on viewpoint, thereby challenging the platform policies and practices around content moderation. The law specifically targeted larger social media companies, framing the issue as one of free speech and alleging that these companies were unfairly censoring certain viewpoints. HB 20 prohibited the platforms to consider users' content based on viewpoint, representation in expression, or geographical location within Texas. NetChoice instead argued, as in Florida, that they have a First Amendment rights as publisher and as private entities. The court concluded that Section 7 of HB 20 does not compel the platform nor does it restrict their own speech. The platform retains the ability to express their views and disassociate from user content, and they are not subjected to content-based penalties or restriction. Therefore, the platform argument that their content moderation constitutes protected speech is not supported by Supreme Court doctrine, and Section 7 is not unconstitutional under the First Amendment. The court concluded that the editorial discretion argument starts from flawed premises. The Supreme Court does not establish editorial discretion as a distinct category of First Amendment protection. Instead, these cases consider editorial discretion as one factor among others in determining whether a regulation compels or restriction protects speech. Premise is also flawed as the platform censorship does not qualify as protected editorial discretion. Comparison between the two. Dissimilarities between Florida's SB 7072 and Texas HB 20. SB 7072 targeted censorship of speech by political candidates and journalistic enterprise, prohibiting censorship regardless of content. HB 20, on the other hand, prohibits some censorship across all speakers, allowing non-viewpoint-based censorship and of certain unprotected expression. SB 7072 provision arguably interfere with platforms' own speech, unlike HB 20. The remedial scheme of SB 7072 and HB 20 differ significantly with SB 7072, allowing substantial fines and statutory damages, while HB 20 only permits declaratory and injunctive relief. Then, is the EU setting a global standard? Case C1818, Eva Glavischnig, Pieszczek versus Facebook Account Limited. This case is an example of how EU is influencing global standards, particularly in the field of digital regulation, data protection, and online content moderation. This case reflects the EU broader regulatory approach, which often sets precedents that have a global impact, commonly referred to as Brussels effect. Eva Glavishnig was an Austrian politician which sought to have Facebook prevent access to defamatory content about her, initially posted by a user on the platform. The content in question was deemed to be insulting and defamatory. The Austrian Supreme Court referred the case to the CJEU to clarify whether a new member state court could order a host provider like Facebook to remove such content and if the order could have a global effect. The court concluded that an obligation imposed on a service provider in the context of an injunction should not transform its role, becoming technical, automatic, and passive. This principle ensures that the provider does not become actively engaged in content monitoring, which would change its neutral status and potentially increase its liability. Active monitoring of content by a service provider is not inherently at odds with the directive, provided it is targeted specifically at certain types of infringement. This targeted monitoring is distinct from general monitoring, which is broadly prohibited. The monitoring obligation must be narrowly defined and focusing on specific instances of infringement and not extending to general surveillance of content. The targeted nature of a monitoring obligation should consider the duration of the monitoring and specific about the nature of the infringements, their authors, and the subject matter. These criteria ensure the proportionality of the monitoring obligation and its relevance to the specific case of infringement. In the context of social network platforms, the obligation involves seeking and identifying information that is identical to or equivalent to the content previously judged as illegal. The obligation is to specifically identify and address content that is substantially similar to the legal content, ensuring that the enforcement is closely aligned with the identified illegal activity and not overly broad. What are territorial consequences of the DSA? The DSA is a significant piece of legislation that we've seen before enacted by the EU to regulate digital services, including online platforms and social media companies. One of its key aspects is how it addresses the territorial reach and implication of its regulation. The DSA applies not only to companies in the EU but also outside the EU if they provide services to insure in the EU. This means that a digital service provider, even if headquartered or primarily operating outside the EU, must comply with the DSA's requirements if it has a substantial number of users in the EU member states. Global tech companies and digital services providers are affected significantly as they must adhere to the DSA regulation to continue operating within the EU market. This includes company with content moderation policies, advertising transparency, and other operational requirements set forth by the DSA. The DSA may also have a broader extraterritorial impact as non-EU countries might align their digital regulation with the DSA standards similar to the global influence of the GDPR. Hate speech and the compatibility of freedom of expression doctrine with what are the probabilistic approaches. So we're gonna see this one after my break. Oof. Okay, maybe this one will be the last bit, so I want to stay up very long, yeah? Hate speech and the compatibility of freedom of expression doctrines with probabilistic approaches. Definition of hate speech. Defining hate speech can be problematic due to this inherently subjective nature. Different jurisdictions and legal systems have a varying definition, often abusing of the intent to incite hatred and the likelihood of such speech causing harm. A probabilist approach would consider the likelihood or risk of certain speech leading to harmful outcomes, such as violence or discrimination against a group. This approach requires balancing the probabilities of harm against the importance of free expression. Instruments like the International Covenant on Civil and Political Rights, ICCPR, acknowledge the right to freedom of expression but also laws of certain restrictions. including for the respect of the rights or reputation of others or for the protection of national security or public order. Courts often employ a balancing test, weighing the value of the speech against its potential cause of harm. This includes assessing audience and nature of the speech. Challenges in applying a probabilistic approach. One of the main challenges is the difficulty in predicting whether a specific speech will lead to harm. This uncertainty can lead to either over censorship or under regulation. Freedom of expression is not just an individual right, but also a fundamental part of democratic discourse. Overemphasis on probabilistic harm could unduly restrict speech that is essential for public debate and social progress. In some jurisdictions like the US, the standard for resisting speech is whether it presents a clear and present honor of causing significant harm. European international human rights laws often requires that restriction on speech be necessary and proportional to the legitimate aim pursued. Additional prevention of cybercrime, the protocol seeks to harmonize law across different jurisdictions to effectively tackle the expression and need for its protection, even while combating hate speech. The diverse legal and cultural backgrounds of different member states can pose challenges in uniformly implementing the provision of the protocol, as it underscores the need for international cooperation in addressing transnational nature of cybercrime and hate speech. Delphi versus Estonia. The case of Delphi versus Estonia before the ECHR dealt with the issue of freedom of expression and the liability of internet news portals for user-generated comments that contained hate speech, threats, and offensive language. Delphi was one of the largest news portals in Estonia. It allowed readers to comment on articles, and comments were not edited or moderated by the company. Offensive and threatening comments were prevalent on the platform. Delphi AS had notice and takedown system in place where users could report offensive comments and the company would remove them promptly. The case arose when an article published on Delphi portals attracted offensive comments directed at the subject of the article. These comments were eventually removed at the owner's request, but the owner claimed damages. The ECHR considered the case in the context of freedom of expression and the balance between protecting reputation and personality rights, Article 8, and freedom of expression, Article 10, under the ECHR. The ECHR recognized that the internet providers an unprecedented platform for freedom of expression, but also acknowledged that defamatory and unlawful speech can be disseminated quickly and persistently online. The ECHR recognized that the internet providers an unprecedented platform for freedom of expression, but also acknowledged that defamatory and unlawful speech can be disseminated quickly and persistently online. The ECHR distinguished between traditional publishing and internet news portal, recognized that the nature of internet media differs. It acknowledged that the responsibility of an internet news portal should be distinguished from traditional publisher. The ECHR emphasized that this case concerned the internet news portals providing a platform for user-generated comments on published content. The ECHR recognized that the value of anonymity in online discourse, that also noted the changes of identify perpetrators. It suggested that different levels of anonymity are possible online, and acknowledged that notice and takedown system, if accompanied by an effective procedure for rapid response, can be appropriate for balancing rights and interests. However, in cases involving hate speech and direct threats, internet news portal may have a duty to remove clearly unlawful comments promptly, even without prior notice from victims or third parties. Loi Avia. The law was adopted in France in May 2023, aiming at combating various forms of online hate speech, terrorist speech, and child pornography. Under the legal landscape foreseen by the law, it was decided that online platforms take down certain types of illegal content within 24 hours of being reported by the users. Failure to comply would have resulted in significant fines. The law shared similarities with the German NetzDG law, which requires the same. Besides, the law required the implementation of a user-friendly mechanism for reporting content, and they had to communicate the results of their reports to users. The Constitutional Court of France reviews the law and struck down many of its provisions, deeming them an attack on freedom of expression and communication. Some incremental reforms remain in the law, such as the creation of a National Prosecutor's Office for hate speech crimes and the establishment of a research watchdog to track online hate. Meta's approach to hate speech. The Oversight Board of Meta. The Oversight Board established Meta is a Supreme Court type body for meta speech governance. The Oversight Board uses an international human rights law IHRL framework to make decisions, particularly focusing on freedom of expression. There is a tension between Meta's probabilistic approach to content moderation, where rights abrogation is seen as investable. The legal framework that is the IHRL, involves balancing individual speech rights with broader public interest, safety, and the rights of other groups. It requires companies like Meta to respect human rights by default, incorporate IHRL into internal platforms law, and justify any content restriction based on principle of legality, legitimacy, necessity, and proportionality. The board's decisions are based on IHRL standards such as the UN Guiding Principle on Business and Human Rights, and consider whether Meta actions align with these standards. Meta speech governance is not guided by an HRL framework, but rather a systemic balancing approach. It has transitioned away from its original approach of limited interference with user content based on a First Amendment-like ethos. Meta's governing documents, such as its community standards and values, mention balancing user speech with other interests such as authenticity, safety, privacy, and dignity. However, Meta's adoption of a systemic balancing framework does not equate to an HRL-based approach. Human rights considerations are not a routine part of its decision-making processes, and the language used in its document is vague and non-committal. Meta's speech governance is influenced by the concept of probability. It relies on implicit rules built into code and algorithms to regulate user speech. Instead of relying on explicit public available rules, Meta uses architectural regulation to shape user behavior on its platform. Probabilistic content moderation focuses on systemic decision-making, emphasizes the need to minimize error and maintain consistency in speech governance. This approach accepts a certain level of error as investable and rationalized in the system design level. IHRL, on the other hand, is an individual-centric framework that emphasizes the protection of individual speech rights and requires case-by-case adjudication of content removal decisions. It is based on principles such as legality, legitimacy, necessity, and proportionality, and aims to safeguard the rights of individual users. So what are the limits on the Oversight Board? Meta has been reluctant to respond to the board's inquiries. While the board has the power to request information, Meta is not obliged to comply with such requests and may decline based on various reasons, including legal, privacy, safety, or data protection concern. This limitation undermines the board's ability to compel Meta to provide information. Meta has always relied on its own initiative and transparency measures instead of tailoring responses to the board's recommendation. This allows Meta to maintain control over policy change and transparency, limiting the board's influence. Meta restriction on the board's power, focusing on politically sensitive cases, and its small size limit the board's ability to serve as an accessible appeal mechanism for most of Facebook users. This limitation makes the board more of a symbolic appeal avenue, particularly for users with non-political enforcement complaints. Meta's limitation on the board's scope and size prevent it from effectively addressing freedom of expression issues for the majority of Facebook users. The board's inability to provide accessible and scalable PR mechanism restricts users' ability to remedy enforcement errors and enforce their freedom of expression right. Now, the final part, political speech. Political speech is a broad category that covers a wide range of communication from individual expression of political opinions to organized campaigns. In the context of the US, political speech is legally protected under the First Amendment of the US Constitution, while political speech, such as incitement to imminent lawless action, through threats and speech that violates laws like libel and slander are not protected, the exact boundaries of this exception are often the subject of legal debate and judicial interpretation. The government is limited in how it can regulate political speech in public forums such as parks or streets. Restriction in this area must typically be content neutral and serve a significant government interest. In non-public forums, the environment can impose more restriction. There is a decision that is important of the Chairman of Federal Constitutional Court on 22 May 2019. A right-wing political party in Germany posted an article on its website and shared it on Facebook page. The content of the article deemed hate speech by Facebook led to Facebook restricting the visibility of the article and temporarily disabling the party ability to post. The political party challenged this action in court, arguing that this freedom for expression was infringed. When preliminary injunctions sought in courts were unsuccessful, the matter was taken to the Federal Constitutional Court. The court granted a preliminary injunction requiring Facebook to grant access to the group until the end of 2019 election. The court evaluated that the harm done by their exclusion from the election was greater than the one by their hate message in their Facebook page. Besides that, the court explained how the fundamental rights could have repercussions even in the positive law dispute. Another important case in 2020 was OOO Flavius and Daughters versus Russia. The case of ECHR focuses on two website pages that have been torn down by Russian government officials, basing themselves in a legislation act of 2013 by the Russian government. The court concluded that the tear down of such sites was not linked to the necessary function of a democratic society, nor it was necessary for any public good, as it was unlawful under Article 10 ECHR. This information is identified as a false or misleading information created and spread for economic gain or to deceive the public, leading to public harm. The process is driven by algorithms focusing on sensational content, a click-based advertising model promoting viral content, and technologies like bot and fake accounts. The Commission plans to take steps in preparing a code of practice from online platforms, both independent fact-checking and enhancing media literacy, and ensuring support at the electoral project. And that's finally is the end. Thanks a lot, because this one is my last presentation for the exam. I will probably do other presentation, but in this case just much more for contents that I am interested personally, and so they probably will be slower in terms of when they will be uploaded. And yeah, thanks for viewing this, and have a nice night.